you. Correct.
Yes.
And you. So, indeed.
Attend the court, please. Susan. Susan. Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39037, State rel CYFD versus Ruben C. Can I have entries of appearance, please?
I'm Susan Baker on behalf of Ruben C., the respondent father.
Thank you. Ms. O'Neill, you have reserved 23 minutes for your argument in chief and 7 for rebuttal?
Correct.
All right, you can proceed.
May it please the court, Madam Chief Justice and members of the court. This appeal arises out of a termination of parental rights trial that was held in the spring of 2019. At the termination trial, the mother was not represented by counsel during a critical portion of the trial. The father was represented by counsel for the duration of the proceeding. The trial court granted the motion to terminate parental rights and both parents appealed. The Court of Appeals heard the mother's appeal first. The court held that mother was denied her statutory right to counsel. The court then reversed the TPR judgment and remanded for a new trial.
That's not the sole limitation of the court's holding.
No, that's not the sole limitation.
Yeah, but
that was
you seem to suggest in your briefing that it is, and here this morning you're repeating that again. The holding was twofold, wasn't it? One was about the standard, and one was about lack of counsel.
So the court held that she was denied her statutory right to counsel and reversed on that basis. The court then went and addressed additional issues in the interest of judicial economy. I think that there was a standalone basis for the reversal based on the denial of the right to counsel. It was not reversed because of the other issues. It was reversed.
I think I can make the argument that it was reversed for both reasons. Because if the clear and convincing standard is erroneous, you would reverse in that instance as well.
Right, and without getting into the mother's appeal, because that's not before us, I think there were issues with preservation with that as well, because that was also a supplemental briefing like the court did in this case, and that issue had not been preserved by the mother as well in that court.
But Ruben C., I mean, that, to me, this is the issue. I mean, Ruben C. builds on Maisie Y. on the standard of review, so you can argue that. Except Ruben C. starts off and says, this is what we held. All grounds to terminate parental rights in ICWA cases, including determinations of abuse and neglect. All grounds, not just abuse and neglect, foster care, abandonment, are beyond reasonable doubt.
Yes.
And I don't think, did CYFD take an appeal of that under Maisie Y?
No, and there was a reason for that, because the department didn't necessarily agree with or disagree with that holding, about that finding, in the sense that the department knew that the Indian Family Protection Act was coming down. That was passed the next legislative session, and that makes the burden of proof beyond a reasonable doubt for all the findings regardless.
But not for abuse and neglect proceedings.
No, it does not. That's only for.
It does not, but that's what this holding says.
This holding is, the mother's holding is related to Indian and Child Welfare Act proceedings.
Ruben C. says all grounds to terminate parental rights in ICWA cases, all grounds, including abuse and neglect, abandonment and foster care, be proven beyond a reasonable doubt. That means in an abuse and neglect proceeding, the first proceeding, that must be done beyond a reasonable doubt. And you didn't appeal that.
Are you talking about at the adjudicatory hearing, like the first finding of abuse?
Yeah.
No, I think that was clarified in a later decision by the Court of Appeals, that they're talking about, they're only talking about the burden of proof at termination of parental rights.
But I think piggybacking on Justice Thompson's observation, in Maisie Y, the conclusion was in all equal cases for all factors beyond a reasonable doubt. You didn't appeal that decision. I understand you're looking into the future and saying, well, IFPA's gonna pass. But it still means that that is an undisturbed ruling of the Court of Appeals that the department did not challenge.
Correct, and I
And
don't,
so it makes it very difficult for me to understand why we are here today. Because if you didn't challenge it then, I'm not sure you can challenge it now.
so the department's not challenging what the burden of proof is. That's not what we're here today for. We're here about the issues that are in Ruben C's appeal,
I understand
which
that.
are the retroactivity.
I understand that, but if you didn't appeal in Maisie Y, why should we hear you about retroactivity in Ruben C? The only consistent way to challenge this would be to challenge Maisie, because you're saying, fine, beyond a reasonable doubt for all factors, but not for this one guy. And that seems incongruous to me, no matter how you cloak it. I understand you're cloaking it in the retroactivity analysis. But if you agree that that should be the standard, why wouldn't we apply it? It undermines your challenge to the retroactivity analysis.
Yes, and I understand that. I will say that the Court of Appeals, the way they did the briefing in this was very challenging for CYFD because it kind of set this up, because what they did is they issued the opinion in Maisie Y, and instead of doing a joint opinion, which I've never seen them do a published opinion where there's two respondents from the same case, where they don't issue a joint opinion or consolidate the cases for the purpose of the opinion.
Mm-hmm.
And so when they issued Maisie Y, and then weeks after that, they ordered supplemental briefing on Ruben C, where they said, we would like to apply the doctrine of retroactivity. What are your thoughts on that? And so I think I don't think CYFD anticipated that.
Mm-hmm.
And to address your argument about, I don't think CYFD is saying that this doesn't apply to this one person. I think that's not quite giving full effect to the department's argument. The department is talking about this doctrine of retroactivity. So mother's reversal was based on her violation of due process rights. The court only addresses the other issues in the interest of judicial economy. Now, an appellate court raising new issues solely for the interest of judicial economy, I couldn't find much support for that they can address new issues. I think they had the option of saying, we want to set these out and we're going to apply and see if these meet what happened in mother's case. They chose not to do that, and they chose to send back down. But those issues were not briefed, and they were not raised by the mother on appeal in that case. She did not raise the burden of proof for the active
I
evidence finding.
understand that. But the court having reached that conclusion, the department chose to take no action on it.
And there's no preservation. I mean, I don't understand the preservation argument in that context. You didn't take, that was the holding of Maisie Y, which, by the way, to me is very problematic. And I don't understand the preservation issue, because once Maisie Y came out and then Ruben C says that's what the law is, and apparently CYFD agreed with it, I don't see what the preservation issue is.
So I think, so again, the department didn't necessarily disagree with that, but I think the way that this, so it's led to, so we started with this termination trial, right? And we started with a denial of a parent's right to counsel. And the other parent, there's no allegations of anything against the other parent. So then both parents just happen to appeal. Neither one of them raises the issues that are decided on appeal. And then now we're getting so far, and I think that's where the department is coming from in this second, or in father's case, is it was kind of like, okay, we can tolerate that holding in the other case, in that initial case, because it's consistent with what the department's position is with regard to the Indian Child Welfare Act, that we want to keep promoting the expansion of rights of tribes and respondents in those cases. But then when we start getting into and saying that this doctrine of retroactivity, that's kind of aside from the Indian Child Welfare Act, and it's kind of aside from those issues. And then the holding about preservation and the exception for fundamental rights of a party, now that got just so far afield that the department just said, hold on, this is really challenging for us, because now we're looking at we're looking at cases where parents can appeal at any time. We've got children in these cases, and we've just gotten so far from this that this was like our limit with this because we could handle the other ruling, but now we're at this point where we are talking about retroactivity and then fundamental rights of a party being a basis for, just because he's a parent and he has rights, there's always a second analysis on fundamental rights of a party. And that's always that there's a right present, right? And then there has to be, that can be waived under fundamental rights of a party. And then, so there's the right present, but then there's also the, how was that right interfered with, or what was the violation? And so if you find that father has, of course, he has his fundamental right to parent his children, but we also go to, just because he has that right, so what was the error? So there was, it's like they're saying, so let me see if I can.
So you're saying fundamental error applies. The analysis, you're not saying fundamental error. You're saying the analysis of fundamental error applies, which requires there to be an alleged constitutional error. As opposed to plain error, which would be evidentiary. Is that?
I think you're saying what I was saying, but I don't think that's what I want to say.
Okay.
Let me clarify. Thank you. So I appreciate that. So fundamental rights. So a parent has a fundamental right in their care, custody, and control of their child, right? So they have this fundamental right. The interference of that comes with the filing of the abuse and neglect petition and the department interfering with the family. And we have case law, and we have due process rights for parents, and we have the parent has all those rights that come with that and the interference. But we have a continuum of proceedings. We talk about it in Maria C. I think in Paul P. talks about it as well. And there's this continuum of proceedings that ensure that the rights are protected of the respondent in a case. And there's no issue in this case that did not occur. He was given, again, mother did not have an attorney during a part of the trial. Father was always represented by counsel. He was always, all of his due process rights were protected. And so I think that's what we're saying. So the fundamental right, so I think I'm just struggling to see how him having this fundamental right was the basis to allow them to review an unpreserved argument. Preservation is a very important issue in these cases. And when I was doing my research, I found a 1982 case by this court, by the Supreme Court, that talked about, it's called In the Matter of Doe. And it talks about when an appellate court raises an issue itself, it risks overlooking important facts or legal considerations when they take it upon themselves to raise, argue, and decide legal questions overlooked by the lawyers who tailor the case to fit within their legal theory.
So if I understand what happened procedurally, correct me if I'm wrong. The Macy Y opinion was issued. There's no appeal of that. Then in the father's case, the Court of Appeals on its own motion requested supplemental briefing on retroactivity of ACY and other questions that are set forth in paragraph 14. And then that's why we're here. Is that right?
Yes, that is why we're here. They had, father did not raise any of these issues himself. They were not preserved in the trial court, nothing about retroactivity or the burden of proof. And then they were also not raised by.
It wouldn't be preserved because that wasn't the law at the time of the trial. I mean, Macy Y overturned case law. So what is it that father would have preserved when the court then kind of pulls the rug out from underneath everybody and says, well, no, we're going to change clear and convincing to beyond a reasonable doubt for this one prong. So it's new law. How would he have preserved it in the first? I think you're fundamentally holding father to a standard that could never be met because he'd be arguing against what was previously clear guidance from the appellate courts.
So I think a parent, so of course we had a draft of the Indian Family Protection Act that was out there that had been attempted to be passed in 2020.
But it didn't, so we can't,
That's correct.
Can't rely on maybe the legislature will get its act together and pass it.
So, but I think that goes to, how did we ever get to where the burden of proof for any termination of parental rights constitutionally held by the U.S. Supreme Court was evidence, clear and convincing evidence? Well, somebody challenged that. Somebody said, well, that's what this should be. The
Yeah,
evidence-
But it wasn't an unanswered, I would agree with you if this was an unanswered question. But here, until Maisie Y was written and filed, there was clear case law saying exact opposite.
And in most jurisdictions, exact opposite. I don't know of another jurisdiction that's come down this way.
I believe Montana has, and it's possible that Washington, if they have not, they are going in that direction. And Alaska's another possibility.
Well, Alaska's already ruled on this,
I'm
so
sorry.
they have to reverse.
So let me ask you, assuming that we believe that assuming we believe it applies retroactively, I think it was your brief that cited a South Dakota case that limited it to cases pending on direct appeal, because I know in CYFD cases, they're a little different than civil cases. CYFD has custody until adoption is finalized, I assume. Are you suggesting that we clarify and limit it in any way to only those cases that are on direct appeal?
Yes, that's what the department is seeking clarification. And even that the term direct appeal, has the notice of appeal been filed? Again, it's per se ineffective assistance of counsel for attorneys representing respondents in our cases not to have filed them on time. So we actually have even an unpublished opinion from the Court of Appeals that said 518 days is okay from the date of the judgment to the notice of appeal. And it creates this problem for us. And I have to say, when receiving this, and I think this is the distinction maybe between Maisie Y and why the department didn't take action, is the department was not terribly bothered by Maisie Y. Again, that was kind of the direction that we were going as far as the burden of proof. But when we hear what happened in Ruben C., I mean, I felt like it was like henny penny, the sky is falling, the sky. Like, what are we going to do? Like, how can I advise my client at this point
Ms.
that a
O'Neill,
child's free
let
from?
me ask you, Ruben C. has been out for 2 years. How many cases have come up where you had to retroactively apply this burden of proof since Ruben C. came out?
To my knowledge, so with speaking retroactively, like where there was an appeal pending,
Where, in any circumstance where there was a proceeding that was tried under clear and convincing and everybody realized, wait, that was the wrong burden of proof, we've got to fix this.
So I cannot say how many ICWA termination of parental rights trials or permanent guardianship hearings, because we would probably extend that to permanent guardianship, and now we would under the Indian Family Protection Act. I can't say for sure how many there were pending in trial court. But I can say that there were 2 that were pending on appeal that this applied to. And we actually agreed to reverse one based on this case.
Okay.
And so there was one that we did a motion in the Court of Appeals to dismiss based on.
Tell me how practically this works then going forward rather than looking back. So you have an abuse and neglect of a child. You would know whether it's an Indian child or not. If you don't know, you must go under beyond a reasonable doubt. Under what circumstance would you not apply beyond a reasonable doubt?
So
in an abuse and neglect proceeding? Because if you don't do it right and you get to termination, then you've acquiesced on Maisie Y on this ruling that it's beyond a reasonable doubt in anything involving termination. That's question 1. 2, doesn't Maisie Y cover foster care and abandonment? There's a number of grounds for termination under the statute. 1 is abuse and neglect. But this, I'm just struggling with how broad Maisie Y was. And the agencies sort of pass on it. There must be some Native American child that says, wait a minute, if I'm abused and neglected, I'm held to a standard that until I'm protected, it's beyond a reasonable doubt because of this decision. Even though statutes don't say it. Clear language, none of the statutes have this. They have it at the termination stage, but not at abuse and neglect. If I'm a non-native child, it's just clear and convincing. The state will come in and protect me under the same circumstances of this case without that elevated burden. How does this work practically at the abuse and neglect stage?
The adjudicatory.
Yeah.
At the adjudicatory stage. So that was the finding. So that was addressed actually on appeal. James M. is the Court of Appeals opinion. And so the standard burden of proof for the adjudicatory hearing is clear and convincing evidence
For what?
for all children.
Okay, so then we go to the termination.
Right.
And in the termination, they say, I want to look at the abuse and neglect proceeding.
Right, and so that's what Maisie Y addressed,
Yeah.
and that is so judicial notice, that's typically what CYFD does to establish the finding that the child's been abused or neglected. So what happens now, and again, I believe Maisie Y addressed this, which is that, so now without more, you need additional, I'm sorry, I think this was in James M. I'm sorry, I've had so many cases, briefs recently. So we have the burden of proof of clear and convincing evidence. The department can still take judicial notice of that finding of abuse or neglect, but the department has to present evidence, additional evidence.
Why? In other words, you can prove something by beyond a reasonable doubt, okay? But it needs clear and convincing. So because of the past practice, they say, well, this is clear and convincing, but it may have been beyond a reasonable doubt.
And the department had considered whether or not to do that at the adjudicatory stage, but there's nothing supporting that in the law.
But why, I do understand, this is probably getting off the topic really, but I think what Justice, to follow up on his question is, for example, if there's a plea and the practice has always been to take judicial notice of the abuse and neglect, and someone's pleading guilty or no contest, or I don't know if they call it a plea, an admission, I guess, of guilt or no contest, why wouldn't they do that beyond a reasonable doubt at the adjudicatory stage? There's nothing that says you can't give them more. I don't know if that's what you're asking.
I think you have to.
The Indian Child Welfare Act sets forth the burden of proof, at least for the active efforts finding, and that's clear and convincing evidence. And there's nothing that states that the burden of proof at the adjudicatory stage is intended to be beyond a reasonable doubt. There's no support in New Mexico case law or statutory scheme or anywhere along that burden of proof is intended to be that. It is important to note that most states actually have at the adjudicatory phase, they have a finding of preponderance of the evidence. So New Mexico actually already has that heightened standard, and so we already meet that heightened standard. And I think that was, there is a concern there. Are we going to make it a higher standard of abuse or neglect of Indian children? Are we going to make it where they are not receiving those protections at that stage, kind of in the emergency stage, going into the child custody proceeding? And so the department believed that clear and convincing evidence was the standard. Now, we already actually had some attorneys putting into practice this approach that we have now, which is the finding of abuse or neglect, that either judicial notice, and then we put on additional evidence of current abuse or neglect by the parent at the termination trial to establish the beyond a reasonable doubt standard. We had some areas that were anticipating that were maybe where appellate courts are going, and because of concerns related to permanency for children, like I talked extensively about in the brief, we had some areas that were already doing that, at least at the termination stage, but they were never doing it at the adjudicatory phase.
Do you believe the Ruben C. holding would apply to a case where the TPR was already affirmed, but the adoption hasn't been finalized?
That's the concern, is that a parent could come and say, I have a fundamental right in my child. It's ineffective assistance of counsel. They contact their attorney and say, please, I see my time is up. You can answer. Okay. And the parent could say, I would like to appeal this. The burden of proof that is now the law from Maisie Y was not applied in my trial.
Thank you.
Thank you.
Good morning, Your Honors. I'd like to jump right in and continue with this because I think you've all raised very important issues about the effect of Macy Y. And in fact, in James M., which is a case that I think Ms. O'Neill and I both handled, she mentioned, I raised that very issue about Macy Y precedent. Are we saying adjudication is beyond a reasonable doubt? The Court of Appeals said no. And so I think as Justice Zamora raised, I think what we're dealing with here is the act of judicial notice. In other words, in a termination hearing, the court is required to apply 13A428B2, that's New Mexico statute for the standards on termination. One is showing adjudication of abuse and neglect. Two is reasonable efforts by the department to address those issues that resulted in the filing of the case in the first place. Under a normal standard, those tiers in New Mexico statute for termination that the court must make factual findings applying the facts to the law is by clear and convincing evidence. However, because of section 1912 of ICWA, the bar raises to beyond a reasonable doubt.
In termination proceedings.
In termination proceedings. This is a tricky one because I raised in James M.
It's not tricky, respectfully, because it's the abuse and neglect standards are clear in the statute. And amazing why the Court of Appeals says, we're going to read this party material. It's not party material. I agree with you on the termination. It's a clear standard of review. And there's a clear standard of review in abuse and neglect. And there's a clear standard of review in ICWA, both with regard to termination and ICWA, in fact, with regard to foster care, says clear and convincing. So Macy Y would be overturning, because foster care could be a consideration for the termination, is overturning ICWA.
And I think the intention of Macy Y was to say that the termination order on its face is invalid, because in that order, the language that the judge used in taking judicial notice of the first tier of New Mexico statute 32A428B2 was to find it by clear and convincing evidence. And Macy Y is saying, no, that has to be found beyond a reasonable doubt. Does that then trigger the adjudication itself to be required to be proven by beyond a reasonable doubt standard? Yodel, which is the existing case on this, would say no, that it's a clear and convincing standard.
But
That
Yodel was overruled by Macy Y.
Well, that's the million-dollar question. I argued that in James M., and the Court of Appeals disagreed with me.
Well,
And they were going more towards the judicial notice aspect of it.
but they didn't clarify that in Ruben C. They repeated Macy Y. All we can do is go by the wording, and I know CYFD went off this way, and you're going off this way. All grounds to terminate parental rights in ICWA cases, including abuse and neglect. All grounds. Abandonment, abuse and neglect, and placement with another family. That's the language.
And I'm not disagreeing with the justices that perhaps Macy Y needs clarification, but as you pointed out, there was no petition for cert filed on Macy Y. And the issue raised in the petition for cert that we're addressing today has to do with the retroactive application of Macy Y. And I think it would be a violation of my client's due process rights to address this greater issue or problem, dilemma, which I raised in James M., but the court didn't agree with me. And no offense to the Court of Appeals, I think they understood what they meant. And it's my understanding that it has to do with those tiers in the statute and the final termination order and how it takes judicial notice. So termination order being invalid on its face.
What's the procedural status of James M.?
We won the appeal, but it was on lack of reasonable efforts under ICWA. It was more of an unusual case. It was factually based. But I did try to raise Macy Y. I still won the appeal.
But not on that basis.
But not on that basis. But the court addressed it and said that Macy Y didn't require the adjudication to be beyond a reasonable doubt. And I think Ms. O'Neill can address that in her rebuttal. So with the court's permission, I'd like to argue the retroactivity piece a bit because that's the issue I briefed. That's the issue that was addressed in the brief in chief. And my responsibility was to address that issue, not deal with the dilemma in in Macy
But
White.
it is related because you're going to argue in part it's a fundamental right. And
Well-
you're going to argue in part the error because of lack of preservation. And in order to do that, you've got to wrestle and I'm going to let you proceed, but I don't agree with you that it's outside the scope of this argument.
I think the crux of our argument is mother and father are similarly situated. They're almost identically situated. Same children, same abuse and neglect case, same adjudication, same treatment plan with different components for each parent. The appeals were bifurcated. They happened about the same time. I don't think the lack of counsel for mother and father's presence of counsel makes any difference. We're dealing specifically with the issue of Macy Y and its application. So the decision in Macy Y comes out, makes this new finding. I agree, it's somewhat new, even if it deals with judicial notice. It's never been held before. And father had not raised that issue specifically. He raised lack of clear and convincing standard being met, but not that specific issue. He raised it more generally. So the Court of Appeals notified me that, what about Macy Y? So I filed a supplemental brief and then I did address it. So to say that the argument wasn't raised or was waived is not accurate. That's the first issue. The second issue is, did this Macy Y case really create, and this is back to what you're saying, I think Justice Thompson, did it really create a new principle of law? Or did it only take the issue of the statutory standards in New Mexico at termination and how the judge has to apply clear and convincing to those standards, period, right? I mean, did the adjudication in retrospect occur by clear and convincing evidence? And the judge didn't do that. He found beyond a reasonable doubt, he found by clear and convincing evidence, So again, they're similarly situated. And if we look at the constitutional issues, which are greater in an abuse and neglect case than they are in a general civil case, we are looking at a fundamental liberty interest in raising a child under the 14th Amendment. We're also looking at due process rights that are implicated. And this is a due process issue, really. It's a procedural issue. You have this case that came down while father's appeals pending. Does it apply? And the third issue is equal protection. These parties are almost identically situated. And then you have all the civil case precedent around retroactivity. The precedent, I couldn't find anything that says otherwise. I mean, it's well established by the US Supreme Court, and clearly the leading case in New Mexico is the Beavers case. So the question becomes balancing the equities, the state's interest in removing the
You're
child.
missing one other equity.
I'm sorry?
There's the equity of the child.
Yes.
There's an interest of the child and the abused child, allegedly. And I see no argument here today that represents the view of the child. And to me, it's significant. As I've expressed in my questioning.
May I address that?
Let me finish my question.
Yes, because I've thought about that. I agree.
Well, let me finish.
Oh, I'm
with the
sorry, Your Honor. Yes.
If I'm a Native American child, I am in a different situation at the abuse and neglect proceeding than a non-Native child. In order to be protected, the Court of Appeals, not the legislature, has written in a standard that doesn't exist in statute. The Court of Appeals did that. And so if I'm a Native child, before I'm protected by the state, I've got to show I was abused beyond a reasonable doubt. Who is arguing that side?
The child's interest is critical, and it's raised in New Mexico statute. If we go to the constitutional issues, it's really a balancing between the state's interest in protecting the child and the parent's fundamental right. State regulation versus parents' fundamental right. It's the Bill of Rights. The child doesn't rise to the level of a constitutional issue. It's a best interest standard, which is statutory, but it's the state's job to protect that best interest. So in balancing the equities between the state's right in protecting the child and the parent's fundamental right, how does
At the termination stage.
Yes, well,
Right.
throughout the case, a parent has due process throughout the case and the fundamental right to raise a child.
It was due process not provided?
Well, that's the crux of the argument. If Macy Y is a new opinion, comes out while father's appeal is pending. If we look at the Beaver standard, May CY did not say how its application should be defined. And if a case does that, that's what applies. That didn't happen. It was left open. In father's case at the Court of Appeals, the opinion did limit under Beavers the prospectivity, the retroactivity to any case that was pending as of March 3rd, 2021. I mean, it's clearly in the opinion. And also any existing abuse and neglect case at the trial court level that's still open as of March 3rd,
So that would mean
2021.
that,
the date of the opinion, basically.
yeah, but if the TPR was affirmed on appeal and but the adoption hasn't been finalized, then they can come and challenge it under May CY.
Well, I think
That's what,
I
that's,
mean,
yeah.
yeah, I hear what you're saying. Are we talking in the hypothetical? I don't know. I'm not allowed to testify of any situation where an adoption would occur if there's an appeal pending or an open abuse and neglect case. And clearly the Court of Appeals saw that, and they saw the interest of the child, the state's interested in protecting the child and balancing the equities, and they limited the effect of the opinion under Beavers to what's called limited retrospectivity. It's not a blanket universal retrospective application. So that child has been adopted and in a home, a secure home for 5 years. And the parent says, well, wait, back in the day, the standard wasn't met, is precluded. They're not going to be able to bring a case.
The concern raised by the department is that you have a case that's pending pursuant to the limited retroactivity analysis, meaning that, say, it's come all the way through the Supreme Court, and we say termination is appropriate. The adoption hasn't happened yet. Isn't that window between final decision and adoption now a weak spot in that a parent can come in now and say, oh, this should have been beyond a reasonable doubt, and it's that time frame that appears to be concerning.
Yes, Your Honor, I agree. And I think it's those cases that are pending appeal, probably not at the trial court level, unless they're just waiting for a notice of appeal, like a
But it
termination.
says any case pending. So if you take it at its literal word, the Ruben C does, do you think that needs clarification?
Well, it says as of March 3rd, 2021. So it would probably be those cases on appeal where a termination has happened. And my guess is they haven't come through the system that I know of. And it's not even an issue. It's moot at this point because the appellate right has run out. I can't imagine there's a case pending, but I don't know. I couldn't prove that. So I think, again, the opinion is narrow. The application of retroactivity is narrow. And it does go broader than father. But father's so clearly identical to mother. How is it in the best interest of the children to terminate father's right and not mother's and leave the children in limbo like that? I mean, there are cases where that happens and there's precedent.
These children have been in limbo. I mean, that's a hard factual pattern to argue in this case. These children have been in limbo for how many years? How many allegations of abuse have occurred in this case?
And I think, Your Honor, to address that, again, we have to look at balancing the equities. I agree the state has a
One of the
right.
equities is finality for these kids, right?
I
Do they have any
agree.
right to finality?
I think the law requires that,
Yeah.
and it's the balancing of interests. And again, we've asked for a remedy of a new termination trial. We haven't asked the case to be dismissed.
I'll let you off the hook on that last question. That's a good point. Let's talk about that. Why a new trial? The father stipulated to a number of things factually. I understand. I think you're going to make an argument on the standards of proof, and that's fine. But the father did stipulate to facts below. Why can't the court accept those facts? And why does it have to be this de novo trial?
I think that's a question that the justices could raise if we're talking an issue of judicial notice. I'll be honest with you, does it just require correction of the termination order itself, which is invalid on its face, based on the holding in James M.
Because I think reasonably a trial court could look at the facts here and say, yes, I use the words clear and convincing because it was my understanding that that's what I needed to do under Yodel. But this meets the beyond a reasonable doubt standard, so I'm just gonna fix my order.
It seemed like the Court of Appeal precluded that though, because they said, well, the state may have come on a different stand. I wasn't clear from the opinion whether you would remand for a whole new trial, all new witnesses.
I think our reason for arguing that is we don't know what was in the district court's mind. Was it just a clerical error? Took judicial notice in the wrong way?
Was it
Or was it-
barely clear and convincing, so they went with it as opposed to beyond a reasonable
Or did the
doubt?
judge
Yeah.
sit there listening to the facts in the case, and in his mind, he applied the clear and convincing standard? And that's the dilemma we have. And I think the father's right is so great because it is a fundamental right, and because he's entitled to due process, that we need to go back and do a new termination trial.
I understand. Expand on new termination trial. Can the court accept the stipulations? The father stipulated the facts, or is it all these experts that are in CYFD's brief? Are we having a whole new termination trial? Or can they look at the record? Can he do a record review?
I don't know of a case where a judge has been allowed to go back and take judicial notice of facts on the record in a transcript of a termination trial. And I think, unfortunately, if a judge has the idea that it's a clear and convincing standard during that trial, the trial isn't meeting the due process right to a fair trial. It just is. The judge was mistaken in his mind in applying that standard. And I don't know, looking at the
And
termination
I'll point out
order.
something else, that you're gonna end up with a new judge. And so how does a new judge step in looking at the record, determine?
I don't think that's right. It was Judge Duran, wasn't it?
Judge Duran.
She's still there.
Not for long.
Oh, and I think
You
you
know
forgive
something
me.
I don't know.
Yeah, no, and so if you're, I mean, I, you know, crystal ball all you want, that's what we try to do all of the time, but we're the Supreme Court, we're not a trial court, trying to divine what was in the district court judge's mind at the time of making the decision on clear and convincing.
Exactly.
Following up on that point, we frequently will review a record and decide whether there's sufficient evidence to meet the clear and convincing standard or beyond a reasonable doubt standard. Can we do that up here?
Oh, that's a good question, Your Honor. That's an interesting question because the plain error standard of review applies from the the respondent parent's perspective. Clearly under the land case, which I cited, it's an Alaska case. And because constitutional issues are at play under our own rules, and specifically Rule 12-231B2, there can be a de novo review. So is that only in favor of the respondent parent? Or is that something that the state can argue?
You tell me what you think.
I think the state doesn't have the constitutional rights that the parent has. And I think based on the due process rights, we need to have a new trial. That it wouldn't be appropriate for any court to take judicial notice of the facts of the first termination trial and assume that you can make a
But
decision
we're not
on it.
taking judicial notice. We're looking at the record just like we review the record in any other appeal that comes to us.
Yes, thank you. It's a plain error standard. Again, I argue that due process wouldn't allow that. And I think, again, we don't know, if we had a judge who thought that the clear and convincing evidence standard applied from the very beginning of that trial, how did that affect the whole
Well, it
trial?
did there wasn't a reason for the judge at the time to think it didn't. No one raised the argument, and abuse and those proceedings have been going along that way for quite some time.
But I think
Yeah.
your point is we can't presume that it met
Yeah.
the beyond a reasonable doubt standard in the mind of the judge.
Exactly. And that's the danger here. We can assume, oh, the judge made a clerical error. Just the termination order is invalid on its face. Or there's that danger that we don't know that that judge always thought it was clear and convincing evidence on that one tier of the statute because of the Yodel case. And I agree we have a problem here and James M., I was surprised the court didn't go along with my argument about the standard at an adjudication. Because I thought, based on Macy Y, I've got it. You know, it's a beyond the reasonable doubt standard, but the court disagreed with me. So I don't deny that this needs to be clarified, and I appreciate your questions. And again, I urge the court to consider it wasn't raised by either party in a petition for cert. And what's before us has to do with retroactive application of Macy Y. And I was talking about the constitutional issues, especially equal protection here, I think. And this is strict scrutiny analysis. We have to look at the parent's right very strongly in this case. And I think it outweighs the right of the state to protect children, especially given that the children aren't adopted. I mean, I agree with you. If 5 years had gone by and children had been adopted, then the state has a much greater interest in that strict scrutiny analysis. And I also believe that, and forgive me, I'm giving testimony, but I think the law is clear that the civil case standard has to apply because the right is even greater than an abuse and neglect case. And the civil case standard is, I don't think the court could go against precedent, but the precedent is so great around how civil cases apply new rules of law retroactively. And again, how do you do it? You look at the facts, you balance the interests. And in this case, it's not a universal application. It doesn't harm children who've been adopted. It only changes the outcome for those pending appeals. The cases that are pending at the district court level will take care of themselves, really, because
There'll be
they
an
have,
adjustment.
yeah, exactly. And unless a termination trial has happened, but they would have ended up on appeal by now. 2021 was 2 years ago.
Could this court change the effective date of the retroactive application, differing with the Court of Appeals, and would that solve some of these issues?
I believe it could. I think that's allowed by the case law. In the many cases I read about the civil cases where the retroactivity principle was applied, again, Macy Y didn't limit its effect.
But what would we change the date to that wouldn't be arbitrary?
I think it's weighing the interests on us.
Would it just be cases pending on direct appeals?
Yeah, it could be. I mean, and then a date certain because,
Well, we have a date certain.
Yeah.
yes, we already do.
Based on
Exactly.
Macy Y, so that to depart from that, we would have to have a reasoned basis for changing it to something else. And if we change it to something else, say we, whatever the date was in Macy Y, we say it's 6 months later than that, then we've created another tectonic shift in what the lawyers are having to advise their clients on, and we've created yet another narrow category of people who will be treated differently than everybody else because we changed the date of the limited retroactivity.
And I think,
2 years has passed.
yes, exactly.
And so to change it would just create confusion.
Because I would think any case has been concluded where this rule would apply. The only hypothetical I can think of would be where a notice of appeal hadn't been filed, but it was never a pending case. A pending district court case where a notice of appeal wasn't filed on the issue right about the time Macy Y came, let's say May of 2021. Perhaps that parent would have an argument. I don't know. It's pretty remote.
Yeah, and if we were to change the deadline, then we'd have some people post Macy Y that are treated in one fashion and others that are treated in a different fashion. And as an attorney, I wouldn't know what to argue
Yeah,
if my case was still pending.
yeah, I agree. And I think I agree with Justice Vigil that this court does have the discretion to expand or limit the Court of Appeals opinion with regard to retroactivity. That's been done in the civil case law over and over again.
My question really is directed to, not only can we do it, but do we fix anything by doing that? And it sounds like we wouldn't.
Yeah, I think Justice
And they
Vigil.
create our own problems.
Would an opinion need to be clear that this judicially created standard of review only applies to 28B2?
Yeah,
Which is
that,
the abuse and neglect?
yes, that was really the holding in James M, and I'll let Ms. O'Neill address that, the later case where I tried to raise the issue as a broader issue of the adjudication itself, and as you've pointed out, doesn't necessarily comply with the ICWA statute.
Doesn't necessarily, so that's a
With-
kind way to
with-
say it. It overruled it amends. At least in the foster care, I mean, it's clear in foster care, it's clear and convincing.
And the standard for foster care removal ties back under section, I think it's 1901 and 1912, if I remember, and I'm sorry, I'm doing my best. It ties back in with the adjudication itself, as you probably are aware. They're tied together. A foster care placement often requires or does require an adjudication. You have an emergency removal in an ICWA case that's very temporary. And then you have to go to an adjudication to keep the foster care placement intact, or the child has to be returned to the parents. And so, yes, if the foster care the foster care placement after the emergency removal is going to stay in place, we are back to the clear and convincing evidence standard on the adjudication. I agree with you, Your Honor.
What about abandonment? B1. If abandonment is a ground to terminate, native child, non-native child, tell me how those would proceed.
Abandonment to terminate.
As a ground to terminate.
I'll give a hypothetical. There'd be an emergency removal. Then there'd have to be an adjudication, or this is under ICWA itself, or the child would have to be returned within a time set by the statute. And that adjudication, because you're going back to the foster care removal, is clear and convincing, I think. But then when you get to termination, 1912 of ICWA is very clear. It's clear and convincing evidence applied to those two tiers in New Mexico statute. So back to what you said, I would agree that the law requires the beyond a reasonable doubt standard to apply to the tiers in New Mexico statute at termination. And that would not overturn Yodel or James M. So in this case, really what we're looking at is the termination order itself. But the problem is, as we've discussed at length, did the judge think it was a clear and convincing evidence standard sitting there at the termination trial as that evidence was heard?
Probably, because you read the statute, it says clear and convincing.
Unbiased, yeah.
So,
It's a difficult case, but I would ask that fathers' rights be held intact, because in the Court of Appeals opinion, as far as father's concerned, be upheld to protect his right, because he's so similarly situated to mother.
I agree with you. I think if it's remanded, there has to be another hearing. In my mind, I can't see a way around that. But I do think, and knowing how long these hearings take and that they're never really done in a day and they have like 3 or 4 settings, weeks apart, I do share Justice Thompson's concern about finality and the children and family, really everyone, having a resolution of this case. Is there anything? I'm assuming there's nothing we can do. I agree with you. I think there does need to be a new hearing. I don't see any way around that, but that is a huge concern. Huge.
I guess on father's behalf, I'll point out that he did diligently work a treatment plan. He wasn't considered successful, but I would say that, he got a psychological evaluation. He did a lot of the treatment. And sometimes in these cases, what will happen on remand, depending on the situation with the children, and we don't know, is there an available family to adopt them? How bonded were they with the parents? There's so many subjective factors. They may decide at the trial court level to give him more opportunity to work the treatment plan before they go back to termination. There's so many different possibilities and so many things we don't know about the state of those children, unfortunately. But I think, again, the law's pretty clear about fundamental rights, balancing the equities in this case. and applying Macy in a
But he
very
had-
limited fashion to father's case and perhaps other pending cases, which are probably moot at this point.
So father had fundamental rights when he made these stipulations, right?
I'm sorry.
What, father had fundamental rights, the same fundamental rights when he made the stipulations that he made at the prior hearing. And this goes to the question Justice Thompson asked, why would he not be bound by those stipulations on a new trial?
The stipulations of adjudication, you're saying, Your Honor? Yes, he would be bound. I agree. I think the adjudication stands. It's more, as Justice Thompson pointed out, the adjudication in the context of the termination hearing and how those tiers in New Mexico statute were addressed by the trial court judge in termination. I don't think we're trying to throw out the adjudication.
Okay.
Yeah. And I know it's very confusing, it's difficult, but given the opinion in James M., and that neither party, neither the state nor myself on behalf of my client, James M., because we won the appeal anyway, we didn't, file a petition for cert on the issue of law.
Well,
So, all right, thank you for your time.
I do have a question with the chief's permission.
Sure.
Is there any way that this court can address Macy EM?
Macy, why substantively to clarify the issue of law? I think absolutely. Again, it's a
How do
plain
we
air
do that
standard.
with the questions we granted cert on?
Well, I'm sorry, I'm going to back up. I agree with you, Justice Bacon.
Yeah,
It wasn't, it's narrow because I think hypothetically you could, but the issue becomes, we didn't respond to those. I didn't look for case law on that issue, and it would be unfair to father. It would be fundamentally unfair to do that. Like he'd get another bite at the apple again because that wasn't addressed. Yeah. And if I had briefed the issue, or if the state had raised the issue, I think you absolutely could. Yeah.
So, but your answer is no.
Because it wasn't raised by the state and we didn't reply. I think hypothetically you could, but yeah, because of the de novo nature of this. All right, thank you so much.
To clarify, the judgment terminating parental rights did say that the department had proven its case by evidence beyond a reasonable doubt. So I think that the court could, based on prior precedent what Justice Vargas was saying about how we've applied, like the court looks at the standard and then applies the facts to that standard, and has done that in the past. I think that is absolutely possible. And I was actually wondering why the Court of Appeals did not do that in Mazy Y, or I guess in Ruben C, but in Mazy Y, I thought that was definitely an option. And just to clarify, I think counsel stated something incorrectly. The state, and in its interest in protecting children, that right is similar to the parent's interest in protecting. That's the Matthews due process analysis. And so we have these equal interests in protecting children. The parent has a right in raising the children, and the state has the interest in protecting children. And I also want to point out that these are courts of equity. Like you were saying, as far as the children's court, and just talking about the children, we've got the second oldest child. I have a child the same age, and he was starting kindergarten when this case started, and he'll be in middle school next year. So if you think about the timeline of a child's life, just how long this proceeding is taking, they've all been involved with CYFD their entire lives. So
What case law supports what I think is your position, that it's just fine to apply a different standard to father than mother? Because that's the Beavers analysis. I mean, it's the crux of where we are right now.
So this is where I think I diverge from you, Justice Bacon. I believe that they are, well, counsel was saying that they're similarly situated. I don't believe they're similarly situated. I think that they might be factually similarly situated in the sense that they're both parents of the same children. They were involved in the same case and their trials were held at the same time, but they're not legally similarly situated. The mother was denied her right to do her right to counsel.
I get to push back really hard on the right to counsel. That is not the issue in front of us. In the Beavers retroactivity analysis, the last factor talks about consistency, essentially. And so whether the parties are represented by counsel or not doesn't mean that it's okay for them to have different burdens of proof. Dad's clear and convincing and mom is beyond a reasonable doubt. What case law supports that outcome?
So we have case law that supports, so we have different outcomes with the same two parents regularly that happens.
Not based on the standard of review. Yes, you can have one parent who's a little bit bad and one parent's a whole lot bad. And so the outcome is different, but they're using the same, viewed through the same legal lens. Here we have potentially two different standards. What law supports that that is okay? Give me a case.
And I'm sorry, I'm not able to come up with a case.
Because there isn't one for a very good reason. We don't treat parents disparately. We don't apply different sets of law to the parents in a case. The law has to be uniform in termination. And what you're advocating here is that we take an ununiform approach. Say mom gets beyond a reasonable doubt, but dad doesn't. And
So-
to me, there's no case law that supports that argument.
So I think the question that CYFD has actually is posing is, how do you get to retroactivity? Because this wasn't preserved, and to get to, he had to preserve the issue in the trial court. That is standard across all the retroactive cases.
Unless
If
it's
you
a
have a-
fundamental right, and parenting is a fundamental right. There's no case that says that it is not.
No, but you don't, but the court's never held that just because we're dealing with a fundamental right, that issues don't have to be preserved, not in that way.
No, fundamental rights is an exception to the preservation rule.
It is an exception, but there has to be like another layer to that fundamental right, just because then what you're saying, there's no preservation in these cases because they all deal with the parent's fundamental right. So now we're just
It's at the court's
exception.
discretion.
Yeah.
The court has discretion to decide which cases involving fundamental right where the issue has not been preserved, that it's going to hear. And that
And we
seems
get
to
to
be what
determine
happened
if it
here.
shocks our conscience.
Right.
But that's fundamental error. This was not fundamental error. The council, they did not allege or argue
is a
fundamental error.
Constitutional right. I think this would be more fundamental rights. Fundamental errors like the right to counsel, that's clearly, there's a constitutional right to counsel. The person was deprived of counsel, that would be a fundamental error. But I think it's different when you're talking about fundamental rights is where would the person's fundamental rights be violated by whatever issue happened in the case? And that I do believe would be discretionary for the court.
I think there is some discretion, but the court would need to use a lot of caution with that because we are now looking, and really, if you read this case, we're looking at the issues not needing to be preserved. Certainly maybe not in Indian Child Welfare Act proceedings, and that we already are struggling sometimes in the Court of Appeals on that issue, and if we go there, then we're just in this, why do we even have a trial court? Because they're not gonna have to raise issues because it's just a fundamental right.
But that goes
Even-
back to why, not relevant here, but if you did, it wasn't preserved in Maisie Y and wasn't appealed at.
Yeah, it takes me, was my very first
They
question
don't-
about somebody else, was why the heck didn't you appeal the outcome in Maisie Y? Because it wasn't preserved there either.
That's
The
where
Court of Appeals reached out and said, we're gonna do this.
But
And nobody has appealed them reaching out and doing something. Sounds like there's been an effort to do that in James N, and the Court of Appeals didn't take the bait. So we're left with, the questions presented for review by you. Did the Court of Appeals err by holding that the general presumption of retroactivity for civil appellate decisions applies to proceedings under abuse and neglect? Well,
We can answer that.
we can answer that, but what you're all asking us to do is to take a holding in Maisie Y, which it sounds like both of you disagree with. I don't care what you think. But that you both fundamentally disagree with, and you're asking us to apply it under a retroactivity analysis because procedurally that's where we are because the department didn't appeal Maisie Y, and now it is the law of the state of New Mexico.
Well, the Indian Family Protection Act is the law of the state of New Mexico.
Well, but so is a Court of
So-
Appeals opinion.
Right.
But let's be clear. The Court of Appeals opinion is the law of the state of New Mexico because you didn't appeal it.
including the lack of preservation.
Yeah.
And that's.
And so I don't see how we punish father for something that procedurally he had no control over.
Including the retroactivity issue.
And I see that my time is up.
You can,
If I may just, Really the big issue, I see why CYFD is here, is for the preservation, the fundamental rights of a party. We've had fundamental error and it's only been applied, I believe, in 3 or 4 cases, the Paul P, Rosa R. It always goes, and I know, no, they didn't even explain, they didn't talk about preservation. There's
But
so
you
many.
didn't challenge it. You didn't say, Court of Appeals, man, did you get this wrong? There was no preservation, and bring it to us. You conceded that point, and now it is the law of the state of New Mexico.
So CYFD always has, when considering whether or not to take something to the Supreme Court, and we have to be considerate that we have children in the case and that this is going to delay proceedings. And I know you're saying this.
And here we are, in the same exact circumstance because it's dad.
But I think that's what I'm saying, like, we can't have no preservation. Like, we can't, like,
But I
that's
don't
what,
buy that preservation is the linchpin of this case because of the procedural.
so there was no, so that was just it. Nobody raised, the Court of Appeals, I guess, preserved the issue. I mean, you know,
I mean, how do we penalize father or the Court of Appeals?
But I think
I
if
would
you're,
say all kinds
how
of
do you
things
penalize
that
the
were
children?
not
How are you going to penalize the children of New Mexico?
But they're
by saying parents have to
penalized
preserve?
anyways,
Yeah,
because
they're penalized no
the
matter.
hearing is gonna happen. The hearing is delayed because father's case is still, I'm thinking, the children, both parents' rights have to be terminated, or the children go back with them. I mean, this case, these children are delayed right here, right now, until father's case is resolved. So I just don't buy that the lack of appeal in mom's case.
Somehow expedited where
Well,
we
it
are
does, because
today.
we didn't, I mean, we could, so like I said, I've never seen them issue a published opinion where both parents are appealed and they did it, and they didn't issue it together. They did it separately in this case. Why? I don't know if it was
But so-
strategic because what they held, they said, you do not, CYFD, they said, we're reversing on due process and then we're gonna get to these other issues. And then they waited until that was done and to then say, oh, is this now retroactive? And then to go to CYFD and say that. And then we're just like, oh wait, hold on, hold on a second, like, what are we talking about here? And that's where the problem came for CYFD again, and then this whole preservation.
And I think the problem came for CYFD before that, because Maisie Y wasn't appealed, and that was my very first question. I don't understand how we even grapple with this, given that Maisie Y is the law of the state of New Mexico, and it's not in front of us to overturn. Assuming there was 5 votes to overturn it, and I don't even know if that's true. And you guys haven't had an opportunity to brief it either, which is another problem. So this is the technical definition of a cluster.
Yeah.
Yes.
Can I go back to Justice Vargas's question, because the remedy is of interest. The court applied the correct standard on the termination under ICWA or the statute or Maisie Y beyond a reasonable doubt. The issue is, as you defined, is the adjudicatory standard that was occurred there. Why could we not remand on that question for clarity by the district court of whether or not, rather than accepting those stipulations, that beyond a reasonable doubt that the abuse stage was met? And why could we not do one of two things? Either do that ourselves as a matter of record review, or accept the stipulations, the factual stipulations of the father that existed in those stipulations.
So let me see if I'm understanding what you're saying. So the court would then go back and essentially, would it be vacating, like the adjudicatory judgment?
We would review on the record, which we do certainly in criminal cases, and look at the record and make a determination that at the adjudicatory stage it was beyond a reasonable doubt that there was abuse and neglect. Or we remand for that particular purpose only.
So we would basically do a substantial evidence review of just the abuse and neglect portion. Whether father's plea was substantial evidence beyond a reasonable doubt that he abused or neglected children.
Better said.
I think that the court has that discretion to do that. I know that it's a little problematic. There was a plea in one, and then there was a trial, I believe, in the other.
I recall he pled.
It's in
both.
both of them.
Yeah.
The different with the 4 children. And so I think the court does have that. I think that could be problematic though, because we've had some struggles with people saying they can go back and appeal the adjudicatory judgment at a later date, and that's not what the law is. That's a final appealable order, and if they don't do that, then that's been waived, that right to appeal that.
Right.
So, and he did not appeal that or raise any issues related to that.
But if the issue here is whether the proper standard was applied, can we just review whether there's sufficient evidence under the proper standard to decide this case?
I think the court could do that. I think the court would have the discretion to do that. There's also,
Would we need argument from the parties before we went down that path, because we don't know what your positions are?
And doesn't that make us a fact finder?
I think there's a possibility. There's that risk of that. I think what you could do is to see if the abuse or neglect was established at the termination trial. And again, the judgment says it was established, because that's what CYFD is doing now, is it's not just the finding of abuse or neglect from the adjudicatory judgment, but the department has to prove that the child has been abused or neglected under 32A428B2, which is that's the TPR, the termination statute that we were using, and that's the first prong that CYFD has to establish.
But my recollection is the problem here is that in the judgment, the court said, I find beyond a reasonable doubt that he abused and neglected children, which satisfies the requirement based on judicial notice of these hearings. And then when you go back and look at the findings related to those hearings, the court says, I find by clear and convincing evidence that father abused and neglected children. So you have this conflict between the two record documents.
Because you can only take judicial notice of that which actually happened.
Right.
You can't add that stepped up review.
But we do know that the evidence relied upon by the court to come to both of those rulings, it was father's plea that he abused and neglected both sets of children. So the question is, can we review those facts, those stipulated facts, under the correct standard, or do we have to send it back for another trial?
So assuming that the court finds that this was adequate, or the exception to preservation for fundamental rights of a party and retroactive. Assuming all of that is correct.
Assume that.
So assuming that, I will say that I might want to think about that a little bit more, but I kind of raised what my concerns are with that.
We did point out that none of this has been briefed.
Okay, thank you all.
Can I ask another question since we're trying to? Could the court say that Macy Y, the holding of Macy Y, is that the mother was denied due process because of lack of counsel, and everything else they say in there is dicta or just an advisory opinion?
I will say that was my first thought when I read the opinion. But given the weight of it, I didn't know if that quite qualified as dicta, a new burden of proof. I do think it was a new rule of law, and
or advisory.
I think that there's an argument that's an advisory. They didn't need to get to that issue. Why they chose to get to it, again, that's discretionary. I guess they didn't need to get to that issue, but they decided to for whatever reason. So,
All right.
Okay. Thank you. Enjoy your lunch.
Thank you.
You as
well.
Yeah, no, but thank you for really, in your presentations today, trying to be conversational with the court and what's otherwise a very challenging case, and know that the court really appreciates your time here today.
Thank you.
All right.
And thank you
Yeah.
for doing this. In the court, please.